Well, good morning, everybody. My name is Charlie, and with me, we have an attorney that graduated from Capilla University in 2007. In the beginning, he spent 4 years as a prosecutor with the Illinois Department of Financial and Professional Regulations, and then he became a partner with Charles Franklin Law Group in 2012, and that's going all the way up until now. And they've helped hundreds of people with licensing issues with the Illinois Department of Financial and Professional Services, and I'd like to give a very, what I'm going to call a corny welcome to Craig Capilla. That's about it. Craig, can you tell us a little more about your law firm than I did?
No, absolutely. Thanks, Charlie. And thank you very much for having me on. I appreciate the opportunity to come in and talk with you all today. As you mentioned, we got the group started back in 2012. It actually pulled us, a bunch of us from a number of different backgrounds. We had started out as a group of 4. We've grown and shrunk. We've done a little bit of an accordion since then, but we're 6 attorneys at this point. We handle a number of different types of concerns. We do a lot of licensing and regulatory work, which is a lot of the area that I work in. We do a lot of insurance coverage disputes. So if there is ever questions about coverage or the interaction between the policyholder and the insurance companies, we get involved in those kinds of activities. We handle a lot of litigation that surrounds real estate. So if it's covering what happens if a transaction has gone bad, or if there's concerns with business partners and dividing assets, and or there's valuation concerns, those sorts of things, construction litigation, all of that, we work in those areas. But again, a lot of my particular focus is on helping licensed professionals. Having been on the other side of this as a licensing prosecutor, obviously I've got some insights into how that aspect of everything works. And so we try to take that same knowledge base and put it to work for the licensees now. I'm specifically here licensed in Illinois and in Wisconsin, although we do represent clients in a number of different states. I want to say probably 20-some states now we've handled licensing matters for folks. In fact, we're probably, between consulting and actively representing, probably 10 or 12 different states just right now with active matters. Again, that's frequently real estate related licensing, brokers, appraisers, home inspectors, and the like, but also medical. We've doctors, dentists, we do some work with nursing homes and that stuff. And we do a lot of work with regulatory agencies and administrative agencies. So everything up and down the food chain with employment and licensing and human rights concerns and all of that. We get involved in those areas when there's a government agency taking a look at individuals. That's where we get involved as well. So that's kind of some background on who we are as a firm and the sorts of things that we do.
Nice. So thank you again for doing this with me. And the major reason that you're here is we're going to talk about the home inspector law. There's a few of us, and quite a few actually, have been going over this thing pretty seriously for quite a while, and just reading it in a very finite manner, and we're finding a lot of things that either conflict with each other or items that we didn't know, or we're seeing stuff coming up on disciplines on people, and so then we go back and research why this happens. So if you're okay with it, I wouldn't mind jumping right in. We did have a few people that asked some questions, so I'd actually like to address theirs first. Jeff Lease, and he's down in the south suburbs, he asked, is it good, bad, or does it not matter that you adhere to a national standard? And for your clarification, Craig, that national standard would either be the National Association of Certified Home Inspectors, or the International Association of Certified Home Inspectors, or the American Society of home inspectors. Those are the two biggest organizations that have separate standards of practice for home inspectors. And they're close, but they're different than what the state of Illinois put in there. So again, his question is, is that a problem? And if you do put it in there and they don't conflict with the Illinois standards, is there something that we should be putting in our contract or leaving it out altogether?
Certainly, no, that's a fantastic question. And I think that's a really good jumping in point. And, as you mentioned, you've got the INTRNACHI standards, you've got ASHI standards, and they run a similar track, but they're not identical. Those are also distinct from just what Illinois has. And this is obviously going to be a pretty Illinois-specific talk, but this is the type of concern. I don't know if some of the viewers also work in other locations, other jurisdictions as well, but you've got some states that have no licensing component at all, and so you're left to deciding if you're going to adopt one of the other professional association standards or not. You've got some states that will even bake one of those standards in. If I remember, I think Massachusetts, if I'm recalling this correctly, I think has basically just scraped the ASHI standards and dropped it into state code. So there's different approaches to this. And so firstly, I think it's important for the inspector to recognize what really does apply to you wherever you're going to be practicing. So like you said, Charlie, here in Illinois, we have an SOP that's just baked into the administrative rules. That has the force and effect of law. So that's it. That's the goal line to preserve your license here in Illinois. Can you go past that? And this is now going directly to Jeff's question. Can you go past that and also incorporate a national standard too from one of the professional associations? You certainly can. And doing so, unless it's directly in contradiction with the SOP that's baked into the state rules, it's just one more step that you've got to follow, but it doesn't impact your minimum requirements of licensing. If it directly contradicts for any reason, then you can't. State law takes precedence. But so long as there is no contradiction, you absolutely can decide to also adopt another standard and state that you're adhering to those. But here's the catch. That doesn't make it a licensing complaint if something goes wrong. But if you say, I'm going to adhere to INTRNACHI, ASHI, pick some other, let's pretend that National Association of Realtors, who likes to get a hold of everything that remotely touches them, let's say that NAR has a standard for this. And you say, I'm following the NAR standards. And then you don't. IDFPR doesn't care. That's not their field. But if your client is dissatisfied and you owe an obligation to that client, you may well have a contractual obligation to comply with that standard that you've incorporated. And if you don't, that might be a lawsuit. You may have a breach of contract, a civil liability to them. So it's never a bad idea to consider. First of all, you absolutely must know what you must adhere to. It's never a bad idea to consider, are there other things out there that would, if I were to follow those guidelines, that would give me a better product, that would make this more usable to a reader, that would give me a leg up and really set me apart. There's nothing wrong with considering that. But if you're going to say that you're going to follow it, you have to, because it's a whole other can of worms if you don't live up to it. And so I encourage everyone to kind of think their way through that and decide, is this something I really want to do? But if you do it, and it's going to be in your contract, here's what I am going to give you, and then it's going to be in your report, here's what I have given you. Those are two steps of that process. If you're going to incorporate something additional, you'd better meet the standard that you said you were going to. Might not be a license problem, but you could find yourself in a courtroom. You could find yourself having to call your insurer if you fall short. So I will say we've seen that a number of times where somebody invokes every professional standard under the sun and hits none of them. They go, well, what's it really matter? I mean, it's not an IDFPR thing. The state's not going to enforce that. Yeah, but tell that to the black robe judge who's asking, is this in the contract and did you meet it? It's a balance, and it's certainly something for people to consider.
That makes absolute sense. Going on to that, though, I do remember that it says in our SOP that we have to provide a contract. So at a minimum, we have to have that statement, and correct me if I'm wrong, please. But the way I read it, at a minimum, we have to have this statement, this inspection is being done to the standards of practice, the IDFPR 1410. That has to be in the contract, right?
Correct. There's a short list of minimum requirements that you have to have in a contract, and that all is captured in the administrative rules. So that gives you the guideposts you need to be able to get that contract, and that's really the starting off process for all of this. IDFPR pays an awful lot of attention to the contract and to the report. And I can't tell you, in the years from being over there and now in the years of being out and dealing with them on the other side of this, I can't tell you that they consider one more important than the other. As far as they look at it, you have to have both of them. You have to do them both the right way. So it's really getting started with the right contract up front sets the stage for, am I encountering risk? Am I exposing myself to liability in this assignment? It really all starts with the contract.
You sparked my mind up. So before I get back to another question, your days as a prosecutor over there, what is typically the path of a home inspector, let's say, getting fined or disciplined or an administrative consent? And I would like to talk about the difference of those too.
Sure.
Administrative consent order. But what is the path? I mean, how does it start? How does the IDFPR even know that I am a home inspector and they should look at me?
So there's a couple. That's a fantastic question. The process is often a mystery to folks, so I think we can probably shed some light on this. There's often just a couple of common paths that a complaint will arise from. The first one is if you are subject already to the rules and regs, meaning, hey, you've decided this is something that you're going to engage in, so you've gone out and got a license. You met all of the introductory requirements. You've submitted the application. IDFPR has granted you a license. Now, all of the technical requirements of that, paying the fee on time, the continuing education, depending upon how you're situated with an individual and an entity license, if you've got that going on, all of those requirements, IDFPR just monitors that itself. There is at any given time over there a continuing education audit going on with some profession. And probably the most common sweep of licensees are the ones who fell short and didn't complete their continuing education requirements. And then, of course, on the renewal application, certified, yes, I did complete all of my continuing education requirements. Especially over the last several years, IDFPR has really sunk their teeth into those issues. It didn't used to be held in such high regard. It got really ramped up for the last handful of years. And I think we're seeing that back off again. But that is in no way meant to tell people, okay, you can go back to sleep on this issue again. Very simply, it's a requirement to maintain your license, and if you don't, it's the fastest path to having that license go away. All right, so that's the internal check of things. Externally, it usually takes somebody being grumpy about something. IDFPR isn't out there driving around trying to check and see if home inspectors are speeding. It's not their bag. They don't have the bandwidth to do it. They don't really have the interest to do it. If there is a complaint coming in on something substantive, something to do with reporting, something to do with an actual inspecting event, that's usually going to come from somebody in the process that's upset about something the inspector did or did not find. And you can pretty much guess which side of the aisle those are going to come from. It's not unheard of to have an upset seller who thinks, wow, this inspector found so much crap. He really shouldn't have. None of that was really important. I'm going to throw this in to be a complaint. On the flip side of that, you get the buyer who a month into owning the property now suddenly has a giant swing and a miss in the inspection process going, oh, how did you not see that was a problem? Because it's going to cost you a ton of money to get it fixed now. That's usually the origin of a complaint that actually has some substance to it. And the department gets that complaint. There's a complaint intake department that just processes, and it's really looking at it going, what division do we assign this to? Oh, this is about a home inspection. Okay, this goes over there then. That's the intake process. Then it goes into the investigations staff. And you would think that the investigations staff is going to take this complaint in, read the complaint, and look at it to go, does this gripe make any sense? Hey, he was 15 minutes late and he tracked dirt on my carpet. Okay, that probably isn't going to rise to the level of a license discipline. But let's just go to look at the report and see what we've got here. Oh, didn't include this statement in here. Oh, I don't see a signature anywhere on this report. Oh, it doesn't look like they met that standard. Now, that's not what the person griping about all this was worried about. They probably don't know. But they might have tripped and fallen into a valid complaint because the department is going to look at things cover to cover to decide whether all of the requirements were met, not just the thing that the disgruntled individual is concerned about. And so sometimes that's how these things get way blown out of proportion in the mind of the inspector that's on the back of this. That guy didn't know what he was talking about. I was right on time. He had his own date wrong, whatever it was. Why am I here? Why am I going through this? The department, once they've taken the complaint in, assumes the role of the complaining party. So they're going to look at this thing cover to cover. They're going to ask, send me a copy of your contract. Send me, I don't seem to have a complete report here. Send me a copy of everything you got. And they're going to go through all of this to make sure that all of the boxes are checked.
Yeah, that's a big wow and stuff. And that's also something I've been kind of stressing, in the last few months, putting all this stuff together. And I do want to talk about your services again in the future, but let's just say that I'm going to keep using me as the example. I want to make sure that my contract, because it's not just a report they're going to look at and they be in the idea of PR, it's also going to be my agreement that I have signed with my client. I want to make sure that I comply, yet I want to make sure it protects my company, my family, along with my report. Is that a service that you provide?
Absolutely. We're more than happy to do that end of things, which I tend to refer to as preventative medicine. I will tell you that some professions are more inclined to use the preventative medicine services that we offer than others.
Yeah.
Some folks don't like to think about having to deal with the lawyer until the bad thing has already happened. There are other folks, though, that are wired differently and go, hey, is there something I can do to prevent this and reduce the risk of something happening? So if it's reviewing the contracts, reviewing a sample report to make sure that the content's there, and I hate to look at, so glibly, but if the magic words are present or not,
Gotcha.
Those sorts of things, always happy to look at that. When people have questions about insurance coverages, am I covered well enough? Do I have the right kinds of coverage? Am I looking at the right areas? All of those things. And I stress the importance of them because I think the more that you can do to prevent the bad event from happening, the better off you're going to be in the long run. You can't prevent everything all the time, but minimizing the risk as much as you can really drastically improves your chances of being able to have a long, satisfying career in this profession, in any of these professions, with the minimal hiccups. The biggest concerns that we see on our end, it's the people that come into the profession like a supernova. I know the future. Let me tell you what the future is going to be. I have the way this is going to go. They normally last a couple years. They knock a bunch of stuff over in the process. and then they get zapped out of the sky because they missed the minimum requirements that everybody has to live by. I'm all for the forward-thinking folks, but you still have to meet the requirements of today, even while you're busy building tomorrow. And so for anybody who's got the opportunity to do that and really just tighten up their operations in the office, then great. Then go out and find out what the future of this is going to look like and go build that. But make sure that you're actually able to get there and see it when it happens by staying alive now, keeping your license, and putting out good, helpful content for folks.
Cool. All right, so let's see if I could do this. So John Ween just posted a question. He's watching live right now. And he asked if you could talk about limitation of liability in Illinois. And he's talking about example, liability limited to the inspection fee. Many of us put that in our comments, excuse me. Many of us put that in our agreement. And he's more specifically asking, does this hold up? And if it does, when does it, and when does it not?
Fantastic question. Okay, and it's one of my favorite ones. I'll talk about limiting liability generally, and then I'll go to that specific example as well. I think all of us at the Franklin Law Group are of the same mindset when it comes to liability limitation. And that, again, that goes back to what I said earlier, which is all of this, the foundation of that protection starts at your contract level. That's when you're establishing the expectations for the client, and that's ultimately what you're going to have to live up to. And I think it's equally important to consider saying, here is what I am going to do for you. Be very clear, be very specific, and jokingly I'll say, use small words. Practically write it in crayon so that there can't be any dispute about, I thought it was going to be this. No, it's as clear as day. This is what I'm going to provide you. That is the basis of limiting liability. But where there might be some concerns, it's also appropriate and can often be a really good idea to come right out and say, and here's what I'm not going to provide you. If there's ever any ambiguity, if someone thinks they might be able to get more or get less. So it's not restricted to just, here is what I am going to give you. You have to have that. But there are certain circumstances where it's appropriate to say, I am not going to provide X, Y, and Z to you. That will be separate. And it has to be recorded in writing. Either it's, I cannot do that at all, or that's not a part of this deal. If you do want this, it's going to be attached to this in a separate written format where we agree to do X, Y, Z as well. All right, so that's limiting liability at its foundation. Going beyond that then are all of what we then start to refer to as the limiting conditions. And that's the classic. If you have any disputes about this, you must notify me about these disputes in 6 forms of writing within 4 hours of receipt of the report, and you can only file a lawsuit on a Tuesday in Wyoming, those types of things.
I got you. It's actually good.
There's a wide range of what holds water and what doesn't. And understand, as a policy matter, most courts do not like to restrict the ability of the party that has been harmed to bring an action and to attempt to recover or achieve relief. So most of the limitations are themselves limited. They're curtailed by case law. They don't hold water very often. But I always remind people this, and going now specifically to the limit of my liability is capped at the inspection fee. Of course it's not. But somebody out there might not recognize that. If it prevents one person from filing a lawsuit against you, it was worth every dollar it cost you to put that one sentence in your contract, right? there's almost no jurisdiction left that will uphold a statement like that because it's impossibly restrictive. If you somehow managed to make $1 million mistake, but you've also codified, I'm tapped out at $300 a liability here, $450 a liability, like, sliding scale depending where you're at and what it is.
Right.
No court in America is going to look at that and say that's really a just outcome. You can contract away some liabilities, but they have to be reasonable restrictions. And when they take it on balance and go, $1 million mistake, $350 recovery, no, that's not fair. That's not equal. But if it is something as simple as, you've got 30 days to notify me if you're dissatisfied, and you must take this to an arbitration, not court, and you're agreeing to arbitration. I'm not suggesting that that's one that I necessarily support. I don't particularly like arbitration, but those are the type that can actually hold water. You're giving someone an avenue, and they're not completely restricted. But as far as assembling contracts for folks, I think there is great value in considering adding a number of these limitations of liability, not because they're necessarily going to hold water if they're ever tested in court, but if it prevents one person from filing a license complaint or filing a lawsuit, it worked. It did its job. And that's kind of how I look at them.
Fair enough. We are getting a few questions, and I am going to get to those because right now there's 3 that are waiting, but I'm going to kind of push them off just a tad. And one of them might actually be, let me see here, not signed before the inspection. You know what, I'm going to pull Scott's up first. And he asked a question. He said, here's a scenario. A client has sent an agreement to sign online. And I kind of do this as well. Part of our system is as soon as we get the order, 2 hours later, an email goes out. It has the agreement in it, and they sign it like DocuSign, and everything comes back, right? So he's asking, what happens if they don't sign the inspection agreement, or they don't sign it before the inspection begins, and, are they supposed to walk away, get the signature later? Where do we come into play? Because it is written that you have to get the signature before we begin the inspection. And that is...
No, absolutely. And that's, not everyone's going to like it, but nope, that is the correct answer. If you don't have signed contract in hand, don't do the assignment. Because look, there's no obligation at that point for the recipient either. I mean, if you don't have a signed contract in hand and you perform all the work and deliver them a report, yeah, I suppose you've got an argument that you ought to be paid for what you did, but that's going to be a little bit more difficult of a fight. So the contract is as much of a protection for you as it is for anyone else as well. So I would say if you don't have something signed back, and look, I'm not talking about wet ink on a clipboard. We've all been there. We know what that one looks like. And that one's obvious, and that makes sense. And half the time, that's in the driveway with them. I'm going to need you to sign this before I come in. Okay, I get it. I know how that works. But a lot of people, like you described, are also going over to an online clickable form via your website, whether it's I blast something out in an email and it returns, or it's even just a website-based portal and click here and acknowledge this. And it's less what people visualize as a traditional contract, and it's really a lot more akin to like a terms of service on a website. I mean, that's basically what it is. All of those from a legal standpoint are a contract, and they are sufficient. But you gotta have it before you start the work. It's critically important to do that.
And it's critically important because liability, you want to protect yourself, and then B, can you be disciplined for starting an inspection without an agreement signed?
That, I will admit, I think is a bit of a gray area.
Okay.
It says that you shall enter into the written agreement prior to the home inspection. Okay, that's the specific language in the SOP. Prior to the home inspection. Personally, I would think that is prior to beginning the physical inspection. Some people might argue, well, it's really all that matters is before I get into the meat on the bones of putting the report together and producing that. And because there's, I think, a lack of specificity in the rules themselves, I think that there may be some ambiguity there. I think there may be some argument there. But I certainly wouldn't want to test it. I do think that the department could look at that and say, hey, you got out of your truck and stepped into the driveway, and the first thing you did was you kind of looked at the siding and then you took a look at the roof. Hey, guess what that was? That was you beginning the home inspection. You'd better have a signed contract, a written agreement before you do that. I got to tell you, I think they would win that argument. So I know one of the things that we're going to touch on here a little bit is some cleanup of the act and the rules. Specifically, the act is due to sunset, and so there's going to be some work coming. And then shortly after the act gets finalized, there's going to have to be cleanup of the rules so that they line up with what the act now reads. That would actually be one of the areas in my mind that could use a little bit of clarification. Not much. There's way worse areas.
That's so true.
But that one does need a little bit of polishing so that I think we all know what the clear answer is.
Absolutely. I couldn't agree more. And going back to the signatures, though, there's a few other things that come into play. Baxter Rodriguez, she asked, are electronic signatures valid? Is there any sort of a loophole where they wouldn't be valid?
So I'm not aware of any loopholes to that. I think we have moved on kind of as a society, as a technology level, that not only are electronic signatures acceptable, I actually think at this point they're probably the most frequent and most utilized. Right on down from the type your name in this box, VeriSign kind of ideas, all the way up to, I mean, even in my own practice now, I tend to have at all times a briefcase carrying an iPad that has that stupid little Apple Pencil. And even with that, I'll pull that out and I'll sign something. And if you really want to get down to brass tacks, that's a digital signature every bit as much as me typing in Craig M. Capilla into a VeriSign box and clicking yes. I mean, it's a digital reproduction. It is not wet ink on paper. Yeah, those hold water. Those hold water in every courtroom that I've been in at any point. And the only place I know of that doesn't still take a digital signature, humorously enough, is IDFPR, that will make you sign things with wet ink if you're entering into a settlement agreement with them. You actually have to take a physical pen and place it to a physical sheet of paper.
Really?
But absent that, every other layer of court anywhere in the world at this point is taking a digital signature. And there's plenty of case law that supports the courts will find digital signatures to be valid for e-signed documents and the like. So absolutely, as a starter, not only are they valid, I think they're actually just commonplace. And I think that's just where we are now. That's the way of the world. So courts have adapted to that, so they hold legal effect. As far as loopholes go, I'm not aware of any. Or let me put it this way, getting into the lawyer's weeds here for a second. Once the signature or something purporting to be a digital signature is captured and appears, it now becomes a rebuttable presumption. Somebody has to now prove, hey, that's not my signature. The initial presumption goes to the recipient who says, I got your signature right here. somebody now will actually have to take steps to disprove signature. That's not to say it can't be done. I mean, I've been involved in forgery cases before. So there are ways to prove that wasn't my signature. And that works on both a digital and a wet ink version of reality. There's different methods and steps to prove that it's not someone's signature. But the initial assumption on all of it, it's going to be a rebuttable presumption. If there is a signature there, the initial presumption is, yep, that's the signature and it's valid.
Fair enough. Now, to add on that, Michael Spagirin, there's plenty of people that use a service called ISN, and that's when they give the contract ahead of time, and it allows you to sign a signature with it, and I use it too. But sometimes I'll schedule an appointment, and then the client will get the agreement, and then the client is going to say, I want a radon added to it. Or maybe I want to do, or eliminate some stuff and readjust the price, but the contract's already signed. Now when I go into and adjust things, it automatically changes the contract. What sort of liability does that put me under?
So what I would tell you there, the issues I see are if there's ever going to be any sort of modification to a contract, that should also be followed up on by an additional writing and confirmation. The act and the rules don't specifically say that, but under kind of common contract law, those sorts of modifications need to be updated and re-executed to be effective. If you're thinking about it like a construction trade idea, it's almost akin to like a change order. And most of the time there's a specific statement that says any change orders shall be in writing and agreed on by both parties. Same kind of an idea here. And again, that's because that protects both sides of the agreement and both sides of the change. If you're having something pre-signed before you go out there and then the terms change, kind of as a best practices component of that, I would say, do the old-fashioned, bring some additional paper with you and a pen and go, hey, hold on, we're modifying this. We've already entered a contract, but we're adding on a radon test, and that's going to be X dollars more. Date this, you sign here, I sign here. Okay, cool. I now have my contract addendum, and this is going in my file, and I'm keeping this, and I'll email you a copy of this when I get back to the office. I'll scan it and copy it to you too so that you've got it. I'm adding it to my file, and now we're okay and we're good to go. And I bring it up in that manner because I'll tell you this. If you're out on an inspection and you're talking to the client or their representative and you decide to add something on and go, hey, holy smokes, I see that thing over there, and we should do that for you too. And you do it, and you don't reduce it to a written agreement, and then somebody gets pissed off about it, probably the seller, and turns it into the state. Guess what? You might find yourself getting called into the state and facing a discipline because you performed services in excess of what your contract said you were going to do. I know that sounds ridiculous, and there are opportunities there where cooler heads can prevail, and the department will also look at it and go, are we really going to ding someone for doing too good of a job and doing too much? But by technical rule, if you did something that wasn't in the contract or you didn't do something that was in the contract, that's a problem for you, and the department may consider that. And then there's also the civil liability exposure of it as well. So I would say before you perform additional service, you can modify. That happens. That's just the way the world works. But before you do something like that, get it reduced to writing and get it signed off on, or don't do it because the exposure is there.
What about other things that might change, such as date? Or in multi-inspector firms, what if they have to switch inspectors and another guy goes out there. Does that need to be re-signed?
So I think the underlying contract that starts things off, I guess it depends on what your format is already in that contract. But I don't necessarily know that it needs to be re-executed. If you know you're a multi-inspector firm and you've already got your entity and your entity license and entity address and all of that stuff is on the contract, then you may be pondering sending out multiple inspectors. If you've already contemplated that, you should include that in the initial contract. If it is something that changes kind of midstream in an assignment, then you should consider adding a modification or an addendum to say, hey, somebody came out to start this process, somebody else is also coming in to take part in this process and complete it. So now you've added the additional inspector in if that wasn't originally contemplated. And at the end of the process, when you get into the reporting end of it, anybody who's a licensee who contributed to the substance of that report, yes, I walked through and checked these systems, yes, I analyzed this component, whatever, those people should also be in the report identified for the reader and, again, for the state. Now, if it's somebody just contributing to, hey, you got a copy of that article I want to cite to? No, you don't have to disclose that person in there. Or, hey, man, I got to get this out the door now, but I can't get to it. Could you just help wrap up the typing of this and get it on my desk in about a half hour so I can just give it a quick run through, sign it, and get it out the door? Okay, if that's the inspector who's sitting there going, yeah, I can fill that out. I can jam those things in for you. Give me your field notes. I can get this in your hand. It's whoever might be taking responsibility for what's contained within the report, that needs to be in there. So what I would say is clerical work or stuff like that, not as big of a deal. But yeah, if it's a modification to the contract, if you're adding people in later, and you'd better have the names of those folks and their license numbers at least disclosed if they're doing anything that goes to the analytical component of this, because not only is it important for the reader of the report to know, but it's also important if the state is looking to see who's responsible, where does this liability chase. You don't want to find yourself in a situation where you're failing to disclose contributors to the assignment. In the alternative, you want to make sure that they have the ability to ask questions of whomever they need to, and it all may be resolved, because they might look at it at the end of the day and go, substantively, we're actually fine with this. You met the standards, you're okay. But if it ever appears that some information was being left out, it forces them to start asking the question, well, gee gosh, why would you want to leave that out? Is it an innocent miss, or are you trying to cover something? Don't ever let them start asking that question. The scariest 4 inches on the planet are between the prosecutor's ears. Don't give them the opportunity.
No, and I'm going to switch scenes a little bit here, put myself back on the camera. It was just you for a while, but this way, just in case anybody, they can see your phone number, they have your email, your website up there. We did have one person asking about prices, and Craig and I were talking ahead of time, and I'm just going to answer this one. He's not comfortable, nor does he feel that it's appropriate to be putting prices of anything up on a webinar such as this. But please, call them up, see what they do. We'll get into other things there. Now, going back, though, to the contract and changing things, all right? I'm going to give you another scenario. I schedule an appointment for tomorrow, Thursday, and the client gets the contract, and then later on, 4 hours from now, they already signed a contract. They call me up and say, we can't do it Thursday, we need to do it next week, Monday. Can you change it? I change it. But I also have to now send out a different inspector than the one that was on the contract in the first place. So that gets changed. All right, so I changed the date, and I changed the home inspector, but we're still doing the same service. All right. does that require a new signature in the contract?
Yeah, I think if you've now made those modifications to contract, yep, I would have it updated. And again, this is a little bit of belt and suspenders here. This is the most risk averse, or this is the least risky method for this. But I would say, yeah, hey, client, happy to help you out here. We're going to make some changes. Understand you're unavailable. We're going to move this to Monday. I am going to have to send a different person out. This is who I'm going to be sending instead. Would you please return this and acknowledge that's acceptable to you?
And you can do that by email? Am I understanding that right?
Yes, you can.
Okay.
That is valid acceptance. You can have, and this is, again, where we start talking about what's an acceptable digital signature and all of that. You can have, and the courts have found, if I send you an email, I'm going to do X for you, I'm going to do it this afternoon, and I'm going to charge you $5. I know we just said I wasn't going to quote fees, but here we are. Okay. So I'm going to do this for you this afternoon. I'm going to charge you $5. And you write back to me in an email, and I say, regards, Craig. Hey, that sounds great. Please do. Thanks, Charlie. Folks, we have a contract. That's what that is. It counts. So in this circumstance, a re-execution of that doesn't necessarily mean, hey, client, get your pen back out, reprint and re-sign and resubmit to me, or go back into the portal and re-execute a full new one of these, because systems are going to work differently and all of that. But I'll tell you this, if you have an email string, thanks for reaching out, we're going to change the date for you to this. I'm also going to send Joe Blow instead of who I was sending. And so Joe Blow, and this is his license number, will be with you on Monday at 11:45. Please confirm. So long as they email back, hey, that's great, thanks, you're here. Nice. Snap that, throw it in your file, and keep it. It's now a part of your contract. You're going to need to have that. But that passes the requirements of what the court's going to look for. That really should pass the requirements of what IDFPR is going to look for, unless you've got somebody who's really got a burr in their saddle. But that's a winnable argument on the inspector's end. That should be perfectly fine. And so that doesn't require you then to completely reinvent the wheel at that point.
Gotcha. No, thank you. That helps out a lot. And so focusing on the contract, item 3, so section 1410-200 in the rule, that is our standards of practice where you could find it. Item 3, and I'm going to read it verbatim here, the name, address, and license numbers of the home inspector and home inspector entity. So the question is, do I have to put my home address, the one that's going to be on my home inspector's license? Do I have to put their home address on my contract for our company?
So remember how we talked about some areas of the law being written better than others and being ripe for some cleanup?
Yeah.
This one right here is very ripe for some cleanup. As far as I'm concerned, the name, license number, and address of the entity and the name and license number of the inspector are really what's being asked for there, because the department already knows to tie the inspector to the entity. And I will tell you, the physical address of all of this is also a holdover that hasn't been cleaned up in a long time. If you go back and look, that SOP, so all of section 210 there, 200 rather.
200.
All of section 200 there has not been subject to a rewrite since 2010, the last time they rewrote the law.
Okay? Now that's the rule, right?
It's in the rules.
But we can do that a lot easier through JCAR.
You can. And yeah, it's always easier to get a rules update things that are changed in the law are much more permanent. That said, you really, I mean, we're pulling the curtain back a little bit kind of on the legislative process here, but that's okay. I would say generally, and I know one of the functions of the group here is going to try to be, a voice for the profession and have that interaction with IDFPR about the law and about the rules, which frankly has been missing since, about 2010 when the board went away. Okay. That's a thing here. And that's actually specific to this profession. That's a pretty big gap here, is there is not constant contact, or at least until recently, and until this group kind of got up and running, there has not been that constant contact with the department. Now, I will say that the folks at the department, particularly right now, are much more attuned to that. So they're also soliciting that input. They legitimately do want to hear from people. But there's been a vacuum in the home inspection profession about getting this communication going back and forth. These types of communications are exactly the sort of things for a major rewrite of the bill, which is about a once a decade kind of thing. All of these are usually teed up to sunset every 10 years. The major rules rewrites usually fall into sequence with that as well. We've just gone through it with the real estate brokers. Home inspectors are in the hopper right now. That's coming up. Appraisers are in the hopper right now. That's coming up. So the last time this segment got a really big fine-tooth comb look over was back in 2010, late 09 into 2010, right when rewrites were going through on all the law. The reason why there is a requirement of a physical address on this thing, and at both levels, on the entity and on the individual inspector, and this is how they both came to be, was back then, the department had to try to find you somehow. And so they needed your physical address. And they would send you by certified mail, whatever it was. Hey, there's a complaint in here. You have to respond to this. Hey, here's this. Please provide us with a copy of your records. That specific language is a holdover to 10 years ago. Because about 5 years ago, the department relieved themselves of that requirement. Now it's, you have to give us a working email address. And we can serve you with any notifications up and through a legal court complaint just by emailing it to you. So if there's anything that people take away from this today, you'd better make sure that the department has a good email address for you, because they will use it and they are under no requirement to physically mail you anything.
And if you don't respond?
And if you don't respond, you can have your card pulled. I've had real estate brokers,
Wow.
appraisers. I don't think I've had it with a home inspector yet, but all have found us after the department has already taken the license away. And they're going, holy smokes, I finally did receive this notification that they took my license a month and a half ago. I never heard anything about it. That can't be. I would never ignore that. You start peeling back the layers on that onion and look at it and go, actually, they've been trying to get a hold of you for 9 months, emailing you to an email address you don't check anymore. Guess what? It has legal force and effect. Here's an area in the rules that I think is ripe to be cleaned up and updated, because I do think it makes sense to have a physical mailing address for the entity, if that's really what's going on. But the physical address of the inspector is a redundancy. What they need to have is email addresses for both, because that's the standard of legal service for the department. Now, I don't like it. I think it's actually abhorrent that they could suspend or revoke a license over AOL.com. Like, I cannot fathom that that doesn't at least have to be a certified mailing, but it doesn't. They changed that law. That's been in place for years now, and that's we're not getting that one back in the box. Okay.
Right.
It would make sense then that everything else lines up with that. So this is one of those spots where the purpose of that requirement in the rules is so the department knows where to find the people or entities that did the work. It's not 100% clear how that's enforceable, but in my mind, if I'm a field inspector for your entity, the department can find me through your entity. If something comes in the mail for me, you're going to give it to me. So if there is an address of the entity on there, my position is that meets the requirement, that suffices. Because it doesn't say anywhere in there in the specific language that it has to be the, how do I put this? The address of record. It just says an address of the home inspector. So there's even a little bit of a distinction there. It could be a P.O. box for all we know. I think for the purposes of the individual inspector performing the service, if you maintain a work address, and that's the address of the main office of the entity, that meets the requirement here and you're fine. So one address is required. But guess what? That's the sort of thing that should be revisited here as there's cleanup being done to the law and to the rules.
And we will. You know, I'm thankful that there's so many people that are involved in this, and it's not just one person doing anything. And it's actually funny that you just mentioned a P.O. box. Mike Steffens just wrote up on there asking if a P.O. box would suffice and if that's okay. And he, you know,
so the department will tell you for licensing purposes, no.
Okay.
They need to have a physical address. The department won't take a P.O. box as far as just their background and what they will accept for purposes of a license. However, from a legal standpoint, if your official office address is a P.O. box, yeah, absolutely. I mean, as long as you can receive mail there, that's the purpose. And again, it's the specific language of this section in the SOP. Name, address, license numbers, home inspector, and inspector entity.
And this is mostly specific being in the contract or in our agreement that we have to put on there. So those items, it doesn't have to be the license on record, is what I'm hearing from you.
Right. Obviously, the license number needs to be, but as far as the official registered address with DPR, that's not what it says. That's not what it's asking for here. It has to be the address of, the address by which you're known generally, which means if your official address is a P.O. box, that would be the appropriate address to put here.
Fantastic. All right, ready for the next one?
Yeah.
Let's cover plumbing, all right? So
yes, let's.
Yeah, yay. So we know we have an Illinois plumbing code, and in the Illinois plumbing code, it states that only plumbers are allowed to inspect, and that's our key word right there that I'm using. Only plumbers are allowed to inspect plumbing systems, all right? We have it in our law that we're allowed to describe in detail with the plumbing system. But, I think it's a play on words, and my question is, what does it mean? What can I do, what can I not do when it comes to plumbing systems in a home?
No, absolutely. I think out of abundance of caution, you really have to try to stick to those two terms of art. And, oddly enough, in this circumstance, it's the plumbers that get to inspect, and you just get to describe. So simply put, for the purposes of a home inspection, as that's drafted, you can simply state what you observe it to be. I saw this in this place, this type of material, something along those lines. I would actually probably steer clear of making assumptions about the condition or functionality of it. I do think at that point, you could probably get away with it, and most people aren't going to be too concerned. But out of abundance of caution, I think those are the sorts of things that, here's what I see here, here's what I think I see connected, this appears to be the material I'm observing, this appears to be, the relative edge. Look, here's a photo of it. It looks like it was installed yesterday.
Yeah, I have to confess, I hate that word appears.
And that's okay. Yeah. It's absolutely equivocating here, because what I don't think you can get caught out doing is making a definitive statement of, is it good? Is it bad? Is it functioning? I think that's for the plumbers. And I think it's appropriate to call out, this should be reviewed by a licensed plumber.
So Mike Steffens actually just brought up a good question here, and and maybe this is something, should we put this in our contract? Because we're supposed to put in there the items, the systems and components that we inspected. So when we put plumbing in there, should we say observed instead of inspected in our contract? Or does it not matter? Or is this something that goes in our report?
I would think that actually goes in both places. And I don't want to overcomplicate things for anyone, but I think it is appropriate to say that, hey, look, we're observing plumbing here. And the reason why I'm observing plumbing, and this is like a little sub note, is per state law, I can describe in detail what I see, but the inspection of plumbing is to be done by a licensed plumber. So please consult with a licensed plumber for more detail on the functioning of this system. All I'm doing is observing, and I'm going to give you detail on what I've observed.
Right.
And then I think another note in the report that says, I observed this, this is what I observed, and I'm making no further statement on that because the state of Illinois says I can describe in detail for you, but please consult a licensed plumber. That's the best way to protect yourself. Sometimes that's a pretty dissatisfying answer because most of you are going out there going, hey, I want to give these people something they can use, man. I want to be helpful here.
Right.
And if I look at this and see this thing's a disaster, I want to be able to say, hey, I've been doing this X number of years and I'm looking at that right now and I'm telling you this is a problem and it's going to need to be addressed. I also think that's an area that can be cleaned up in the law and in the rules, having discussions with the department about, hey, this is a conflict for us and we need to clean this area up a bit because it's going to be important for us so that we're providing a good service for the public. But we also need to know what's our lane clearly and definitively so that we can stay
Without
in
a
it.
doubt. Yeah.
Just like, for example, a changeover that's kind of come on with real estate appraisers is a lot of the lenders in that field have gone now to what's called hybrid or bifurcated appraisal reports. And it's specifically utilized where they send one person physically to the property to do all of that. And by the way, as a term of art, they also use inspection. I've been yelling at that. I've been yelling at the feds about that for years. It should be observing. It's observing. It's not inspecting a thing. It's observing. But I'm losing that battle too. Anyway, they send somebody out to observe the property. Somebody else sitting back at their desk actually analyzes the sales, crunches the numbers, comes out with the value. That person hasn't left their desk, has never seen the subject property. And this became a hot button item about 18 months, 2 years ago, nationwide. How are the states going to deal with this? And had people flipping out about all of it. And Illinois, I think rather astutely, came out with an interpretation of how this can be done. And do you need to have a license? Do you have to be a licensed appraiser if you're the one doing the on-site observation and inspection? And this is an area where, again, there's conflict between two laws. This time, it's yours and it's the appraiser's. And on this one, the department actually came out and looked at it and said, actually, home inspectors are the ones who are licensed and authorized by the state to inspect 2 or more systems. So everything being done in that circumstance is under the Home Inspection Act, with the carve out that also says an appraiser licensed by the state in the performance of his or her role as an appraiser is exempt from needing the home inspection license. So it's actually the appraiser that gets a dispensation from the state to step on a property and look at things. But if anybody else out there isn't licensed, it ain't the appraisal board that's going to go after them for this. They're going to get whacked for unlicensed home inspection, because that's how the state of Illinois views this. And it was where those two laws ran into each other. They parsed it out and went, this is actually an inspection problem. This is, if you're not coming up with some sort of an opinion of value, this isn't an appraisal question. So this is rightly a licensed activity of a home inspector. This same kind of conflict between the plumbers and the inspectors should be the sort of thing that the department wants to clarify, so they can figure out, if they have to go after someone, which law are we using? And I think there is room for that cleanup, and I think they'll have that conversation.
Without a doubt, I couldn't agree more. And I just want to be clear on what I heard. The appraisers, because I am ignorant when it comes to the law and the appraisers, all right? I have not even looked at it hardly at all. They have a line in there that says they can inspect according, under their, do whatever they do, right?
Sure.
Okay.
They do. And it's in the License Act for Home Inspectors that there's a carve out. There's a line that says appraisers acting under their own appraisal license are exempt from needing a license under the Home Inspectors Act. But then appraisers themselves also have language that they have to insert that says they are not a home inspector. This is not a home inspection.
Right.
And that, buyer beware and consider getting a home inspection too, because that's not what this is. But the only thing that even allows them to go on premise and make a physical observation is that they have a specific exemption in the Home Inspector Act, because it's actually your sandbox, not theirs. They just get special permission.
So maybe we should be working on, some sort of limitation that we put in there regarding plumbing and plumbing observation and plumbing inspections. And I might be working with you privately to get some sort of wording that we could coach people into putting into their reports. But I want to focus and dig on this a little bit more. So, and I'd like to throw scenarios at you, all right?
Sure.
I am inspecting a house, and I'm running the tub, and I go underneath, and the drain for the tub is leaking. Can I tell my client that drain for that tub is leaking?
I believe yes, because you just observed a leak while you were there.
Okay.
Even better if you can somehow snap a photo of
or a video.
Leakage in some way. If it run up, if you've got video and here, look at these droplets. That to me is completely acceptable within the practice of home inspection. You've merely observed and you're describing in detail what you've observed. Hey, I see this thing leaking. Here's a snap of it. Yeah, you're good.
And then going into the inspection part, let's just say that we're not intimately familiar with if it should be a 4-inch pipe or a 3-inch drain pipe and how many cleanouts and how far apart it is. In that disclaimer, that's where, we could say, hey, listen, we're only observing or something like that, right?
Yeah, I think that's the right approach. And I'll admit, I've got some concerns about this. Some of you all are perfectly well qualified to actually make a definitive statement about you should have used this and not this, or code requires X, not Y. Like, there's plenty of you who are actually schooled in that. So this particular restriction is really more about protectionism than it is about any real legitimate concern or purpose. But here we are, and this is what we have to deal with.
All right. So I'm going to back you into a little bit of a corner, so let me apologize in advance.
No problem.
And we're going to take it to another level, all right? The SOPs do not limit any sort of tools or equipment or anything else that we want to use in order to do our inspection or in order to do our observation and description of plumbing systems. So there's sewer scopes, clients that are buying houses, they want to know what is the condition of the underground sewer lines from the house to the street, and that requires removing a cap and sticking a camera and equipment that we purchase to do it, and we charge extra for it, to do that particular service. Am I going to get in trouble with anybody? And it's okay if you say yes or no. I'm not asking for you to decide my thing. And if you don't know, I'm okay with that too.
I think on that one, I think my concern here is...
Boy, I caught you off guard. I am so sorry.
No, that's okay. I think I want to say this.
Yeah.
I think if that's the sort of thing that you have agreed to in your contract and that you are going to perform that statement, or you're going to perform that service and it's agreed to in contract, I think you can, but I think you want to limit your statement about what you observe. And so again, I think maybe that yields a call out to here's imagery that I took of it, and here's what I was able to observe. And my process of observing was I used this equipment to identify that thing, and here it is. Here's what I have seen and observed, and you, the recipient, ought to contract with a licensed plumber to carry this further. And I don't know if that directly answers the question or if that gets you there, but I think that is within the scope of what you as an inspector can perform. Because again, when you're looking at that specific language in the rules, what it's really referring to, again, for your purposes as an inspector, is that when you are agreeing to look at plumbing as per the contract, and it's a part of this, what you're going to do,
Or an
you
extra
must do
service.
that. Right. If you're doing that, you shall describe in detail these items.
Okay.
And I think if you've done that, you've stayed in your lane.
Okay, fair enough. And then here's another one. I'm going to pop Mike Steffens up again. And, what if the seller of the home says, no, you can't? Or they don't want us to do something, in their home? That's a good point. How do we don't have any authority, do we? It's still their home.
So if you run into a circumstance where the actual property owner is essentially interfering or restricting you from being able to perform your services fully, I think there's a couple of steps to trying to resolve that dispute, what I'll call it. And first, I think it's whether you're dealing with them or with their representative or whatever. I think the first thing is actually just explaining, like, hey, here's my responsibilities. Here's what I'm obligated to do. And as a part of it, I am supposed to observe and report on these systems, and these are the steps. And it's like, look, I'm not doing invasive work, assuming that's not some sort of requirement, but typically speaking, I'm not doing any invasive work. I'm not going to start knocking holes in your walls and find out what's under there or anything. But if it's open and readily available for me to observe, I'm going to observe on it. I'm going to report. If it takes me doing any other special steps here, some of those add-ons, and I've been contracted by my client to perform that as well. And so I need to do that. And I go, absolutely not. We're not going to allow you to do those things. If they won't permit you to do it, I think it's absolutely appropriate to, first of all, go back to your client and say, this is the roadblock I've run into, and I'm not being allowed to complete what you've asked me to do here. Do you want me to proceed? They might look at it and go, screw it. I don't know what they're hiding, but no, let's get away from this altogether. Or they might look at it and go, all right, do the most you can. At which point it falls back into, capture that conversation somehow in writing. And sometimes it's the self-serving email. Hey, client, pursuant to our conversation this afternoon while I was on site and the homeowner was interfering with me, I told you that I was unable to access XYZ and they refused to permit me access. And you said, go ahead and do the most you can anyway. I have done so, and I will have my report to you on the parts I was able to do shortly. That's completely self-serving email at that point. But it's also contemporaneous evidence that you're doing what was required of you. That holds water.
Nice.
And I think it's also important at that point to note in the report, I was originally supposed to observe XYZ. The owner or their representative didn't allow me to do so. So forgive me, I've been unable to complete this portion. I do not know if I will be able to get access later to do so. However, in order to get this report out and completed, these sections are not complete because I was prevented from observing these things. And I think you've covered yourself there as well. And if it becomes a problem at that point then with the owner or the seller, or something ever comes up later, maybe they still do the deal, the transaction goes through, and now they come to find out that one of those areas where you were prevented from observing was a problem spot. One, you've eliminated your liability there. You're not responsible for the things that you weren't permitted to see. And two, there might be a whole heap more liability now on the seller or their rep for taking active steps to prevent discovering those defects. So you've officially transferred your liability at that point, and you've kind of done the best for yourself you can by getting the green light from the client. Do you still want me to do this? Because they're preventing me. Yeah, go ahead. Do the best you can. Okay, great. I did the best I can, and I was unable to see XYZ, so can't say anything about those. You've taken that off your plate. Now it's other people's problems.
Nice. And would the same thing go for, lead paint, asbestos, things that might be on the disclosure form and are not part of a normal home inspection, and our client wants us to go ahead and take a paint sample or an asbestos loose piece there, and the seller says absolutely not, we don't want to know. We don't have any authority to do that, or we do?
So absolutely. First of all, if those are the sorts of things that you think might be merited on this particular assignment, get that as add-ons, but specifically addressed in writing with your client. Hey, I was walking around here. I think it might be worthwhile. You might want to have this checked for asbestos or something. Get that back in writing that they actually want to have it done. And then if the owner, if their rep says, no, absolutely not, you can't touch that, I can't let you into that, you're not going to do it, then you can only report that you've been prevented from doing it. But I say, don't even try it, don't even do it, unless you first have it in writing that your client wants you to do it. That's what starts the argument. First, have the explicit instruction from your client to do that step. Then document if somebody else is preventing you from doing what your client asked you to.
Cool. All right. You ready to switch gears a little bit?
Absolutely, we can do that.
And let me know if I'm eating up on your time. We're an hour and almost 20 minutes into this, and I'm good to go all day. I'm having a blast.
No, I will say this much. If you wouldn't mind, and I apologize for this, so that means if we have to tee this up and do it another one at a later date,
all right,
happy to do so. I would love to. If I can actually jump off probably in about the next 5-10 minutes, I do have another thing I'm going to have to attend to, and I apologize.
You're fine.
I would have scheduled that out a little bit further, but we can always, I'm more than happy to come back and do another one at some point too. If there's still questions flying in and all of that, we can get to questions.
I love it. So let me just get two more, and you can answer them as fast as you can, all right? The first one is going to be commercial properties. In our law, it states that anything that is designed for residential. So I read that as being, 15, 20-unit apartment buildings. If somebody wants to hire a person to do that, that person needs to be a licensed home inspector. I know that residential inspections or commercial properties is defined differently in other laws, but how does that pertain to our law?
So that's a great spot. It's a good question. I will give you just the
And remember, I
1,000
got
foot
one
view of
more.
that one. Absolutely. And I'm going to do the short answer on this one because I think this is an important area to seek clarification with the act and the rules being updated. So that 4-unit idea that's out there is actually for real estate, for residential real estate appraisers. And that actually comes down from some statements given by the feds who are regulating the valuation process. And the idea is residential certified appraisers there's 2 tiers of licenses, and residential certified are somewhat restricted in what they can do. So they can do up to 4 units as a residential appraiser. Anything above 4 units is determined to be commercial. Now, if you're just doing a single one of those units, residential is fine. But if you're doing the building in a package, anything more than 4 is commercial. Similarly, if it's mixed use. So I don't care if you're an apartment over a storefront, but you're doing the building, that's a commercial assignment. Unless you're just doing the living unit, then that's residential. So that's where that gray area starts to pop in. The inspection law, though, says property that's intended to be a residence, period. End of story. It makes no distinction. That's a problem to me. And I admit it's a gray area. And the first thing that springs to mind to me is the condo tell. That is Hancock or Trump buildings down in the city. There are folks that own individual units in that, but it's a hotel property, right? It's commercial all day long, every day and twice on Sunday. But it's absolutely intended to be a residence for at least some of the people that live there. Does that now make it a residential property? Because it's intended to be a residence. This is a nightmare of a question, and I think it needs cleanup.
Right.
Because that, I don't know, is an answerable question. Taking that as an example, I don't know that you can get a good answer to that question based on the language that's in the act, in the rules right now, in the code. That is a gray area. I think the department would look at it by saying individual living spaces is really what we're looking at here for purposes of a transaction. But that's not specifically what it says. That needs to get cleaned up.
All right. And then I do have one more. It's good because a few people want to know about that sewer scope. So I'm glad we talked about that up. Somebody was asking about sprinkler systems. Is that the same thing as plumbing, since it must be inspected by a sprinkler contractor? We don't have to answer that one right now. I'd like to go all the way back to one that was way in the beginning by Will Decker. And this is talking about field inspections, and this is for new inspectors. So somebody goes to school, they have to do 5 field events. The law states that in order to do an inspection on a property, you have to be a licensed home inspector, okay? And yet, it also says that in the definitions under field event, that the candidate has to do the inspection while being supervised by the inspector. All right? Now, going with that question, because I know you're out of time, and that's why I want to get this out real quick and let you finish. Will also asked, can the person who's doing the field event, can they just fail somebody? Can they say you didn't do it well enough and this isn't going to count?
Well, I think it's incumbent upon the licensed inspector at that point, well, I'll say the supervisor, to use adequate judgment. I mean, if you cart someone out there with you to do a field event, and that's intended to be part of the 5 that goes to this individual's training and ultimate certification, and they do a crap job of it, I think it's incumbent upon that supervisor to say, hey, this isn't good enough. We cannot count this. I'm not going to sign off on and verify this event. We've got to do better. And that opens up a whole other can of worms, I realize, because I understand, again, that's a bit of a gray area here that I think the state needs to do a better job of actually clarifying what's intended to be done here and what needs to happen. But yeah, not only do I think it's appropriate, I actually think it's required that if you're supervising someone and you don't think they meet standard, I mean, I don't know that it's a legal requirement of your license, but by golly, I think it's for the betterment of the profession that you don't just sign off on something and give someone credit if you've observed that they're not getting it and they're not capable. So I don't know if that's a great answer, but certainly my position on that would be the purpose of having these events is to try to develop competency. You're not doing anybody any favors.
I think this falls
You're
under
not adhering to it.
I think this falls under the time to talk more. You know, with the idea of PR, as you mentioned, on a bunch of things. So,
Absolutely.
well, I'm going to say thank you. And
Thank you
I know
very
we've-
much. I appreciate being here.
Oh, we've had some discussions, and I just want to put out there that Craig has joined our Facebook group. Charles Franklin Law has agreed to become a sponsor, a vendor of our association. All right, so they are going to be accessible through our forum on the IHI. They're also going to be accessible via email. You're going to see ads from them, and you're going to see banners from them. I think you're going to be a tremendous asset, and I can't do anything but say thank you again. And I really want to hit that corny applause thing again, but I promised I would only do it once. So with that being said, if you have
thank
any
you for
final
having
words, you got it.
No, absolutely. Thank you very much for having me on. I look forward to seeing how we can help the group, and I look forward to seeing kind of the profession continuing to grow and advance. So thank you for inviting me on. We'll absolutely set up another one of these at some point. And yes, I'm going to jump in. I'll check questions in the Facebook group and all that. So if I'm able to answer stuff, I will. If I'm not, I will say that as well and go, hey, I can't touch this one. This is too close to legal work. You got to call me, so at least there's some attorney-client privilege and all that. And I very much appreciate the time, so I will wave off now. But thank you very much, and I look forward to working with you again in the future.
You as well. So I'm going to let this video run a little bit. I'm going to put a title screen on, but you can go ahead and just click off when you're done. All right? And thank you again.